Hello, 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 everyone. Happy Monday. This is attorney Ifama Odunlami from the Odunlami law firm, um, coming with a really great topic for you today. So I'm going to wait for people to come in. And please, when you come in, let me know you're here. Say hello. Tell me where you're checking in from. So, for those of you who do not know me, my name is Ifama Odunlami. I'm an immigration attorney from the Odunlami law firm. We're located in New Jersey, but our law firm serves all clients in all 50 states of the United States and even abroad. People who want to file for their family members abroad, we assist them. People who are abroad trying to get in here because they might have qualified while they were here in the United States, we assist them. So my office number is 973-993-1900. Please feel free to call, or you can go to my website, www.odunlamilaw.com, and book to talk to any of the attorneys in this firm. So today, I really wanted to, there was something that happened, I think it was last week, and it really, really, really touched me. And I wanted to talk about it because I feel like I have not given this topic enough attention recently. And I'm talking of people who are living with abuse and who can qualify for a green card. So we had a client that we were able to get a green card. They were married to a U.S. citizen. We filed a petition. They got a green card without even an interview because, we prepared a really strong showing of a bona fide marriage. So we gave the client the green card, and that was when the client broke down and said, telling me everything that was going on in the relationship. There was such horrific abuse, such horrific physical abuse. And I said, don't you listen to my videos on VAWA, Violence Against Women's Act? So I feel like, where did I, how there are people out there who are not aware of VAWA, Violence Against Women's Act, right? And I want to talk about this. So if you know somebody who is in a bad relationship with a U.S. citizen, a green card holder, who's a child who's been abused, or a parent who's been abused, please give them this information because it's really hurtful to know that somebody is going through pain that they don't need to go through because of a lack of information. So today, I'm going to be talking about the Violence Against Women's Act, or AKA VAWA, right? And I'm going to talk about what it means. Basically, just give you the guidelines. What do you qualify, and what you need to show to get a winning VAWA case. So first of all, let's talk about the background. VAWA, Violence Against Women's Act, stands for, it's an acronym. VAWA stands for Violence Against Women's Act. The title is so confusing because it makes you think that it's only for women, but we know it's for men as well. Women, men, children, parents. And then the violence makes you think that it's something that has to be physical. So I'm going to talk about all of this and basically, tell you what it is. Violence Against Women's Act applies to men, it applies to women, it applies to children, and it doesn't have to be physical violence. I'm still shocked when people come to me and say, I was going to file for VAWA, but the attorney I went to said I didn't have a police report or I didn't have hospital records. Guys, if there's one thing you take away from this today, VAWA does not require a police report. It does not require a medical report. If you have those, fantastic. Most of the cases we have won, most of our cases are not even physical abuse. It's all emotional, psychological. Those people come to us. Sometimes we get the physical abuse, which is fantastic, but you can win a VAWA case without having been physically abused. There are other things you have to show: emotional abuse, psychological abuse, financial abuse, verbal abuse, sexual abuse. There's a whole slew of abusive behavior that qualifies for VAWA. So who are the people that qualify? Hi, Ayodele, how are you? Thank you for joining me. Who are the people that qualify for VAWA? Well, if you qualify for VAWA, if you're married to a U.S. citizen or you're married to a green card holder. So you're married to a U.S. citizen or you're married to a green card holder and you suffered abuse. And it has to be a bona fide marriage, of course. And then there are other qualifications, which I'll go through. But number one, spousal relationship could be, as long as you're married to a U.S. citizen or green card holder, it could be a same-sex marriage, it could be a heterosexual marriage, doesn't matter, because in the United States, gay marriage is law. Now, the only caveat is if you're married to somebody and in the country that you got married to them, if you're married to somebody in a homosexual relationship and you get married to somebody abroad and that country does not recognize your gay marriage, then U.S. will not recognize it. So you have to be married in a country that recognizes gay marriage, okay? As long as it's recognized there, it's recognized here. So the second thing is, if you're the parent of a U.S. citizen who's over the age of 21, only a U.S. citizen, not a green card holder. So you have to be parent of a U.S. citizen who's over the age of 21, and you're being abused by your child. Like I said, it doesn't have to be physical abuse. It could be a child who's taking advantage of you, cursing you out, misbehaving, that kind of thing. That could qualify you to file for a VAWA based on the abusive conduct of your child. Now, number three, if you're the child of a U.S. citizen or a green card holder and you're under a certain age, you have to be under 21. If you're the child of a U.S. citizen or green card holder, you can qualify to file for VAWA. Now, you could also qualify if you're a step parent or a step parent or stepchild, but you have to show that the qualifying relationship happened before the child was 18. Now, there's some exception made for people, for young people to file VAWA when they're a little older. If you can show that the reason you didn't file for VAWA when you were 21 or less than 21 was because of the abuse, right? Then you're given till you're 25 to file for VAWA. Now, another category of people that can file for VAWA are the parents of an abused child. So if you're the parent of an abused child, even if you were not abused yourself, but your child was abused, you could qualify for VAWA. So if you know anybody who qualifies in any of these categories, please share this video. There's so many videos on VAWA. Nobody should be in a bad relationship or suffer, because they want to get a green card. The law protects you. The law does not want you to be in an abusive relationship, okay? So now, the thing about people who are being abused is this. Sometimes getting the evidence to show the abuse or show that, they qualify can be quite challenging, right? So as a result of that, USCIS has pretty much lowered the burden of proof to any credible evidence. And that's such a great thing, because I have clients that come here and say, oh, I can't file because I have no proof of this, I have no proof of that. And we tell them, we just have to think outside the box. What do we need and how can we get it? So to file for VAWA, of course, you have to show that the person is a U.S. citizen or green card holder. You have that qualifying relationship, right? And sometimes it's hard to get proof that your abuser is a U.S. citizen or green card holder. And so some of the things we've been able to use to show that are a marriage license. In some states, the marriage license will indicate where the person was born, right? So we can use that. We could look for voting records, public inquiry. Just go on Google, see where if the person has voting records, have they voted? If they're voting, chances are that, they're U.S. citizen, right? And you can show that, right? If they've ever filed an I-130 application for you or for a family member, you can do a FOIA, and, an I-130 approval can be evidence that there is a qualifying relationship, that the person is a U.S. citizen or green card holder because they filed an I-130 that was approved, right? Hi, Ayodele. I'll get to you once I finish and I'll answer all the questions, okay? What else? How else have we been able to prove that the person's a U.S. citizen or green card holder? We've been able to do a FOIA, Freedom of Information Act, and to get the records of the person, because there was a time we had to file a case for somebody whose husband was deceased, and she had no record, nothing, and we're able to get a FOIA, and we're able to get the naturalization certificate from there. So sometimes you really just have to think outside the box. I mean, the possibilities are endless. So you really, just talk to a lawyer. You'd be surprised at how you can get what you need. And I'm telling you, it's just so heartwarming when a client comes and thinks they don't have a chance because they don't have this, they don't have that. And we're able to, put a package together, just because we're thinking, proactively, get them all the things that they need. And sometimes we even ask USCIS, here, USCIS, you have this information. So why don't you, this is what we have. Why don't you bring proof that the abuser is a U.S. citizen? Sometimes we do that. So if you don't have the evidence, that should not be a reason for you to think that you're not eligible to file for VAWA, okay? So the other thing is, so you want to show the person is a U.S. citizen or green card holder. You want to show that there's a qualifying relationship, right? And the second thing is, if it's a marital relationship, even if it's a non-marital relationship, you do have to show that you've lived with the person for some period of time. Now, the good news is this: there's no limit to how long you should have lived with the person. There's nothing that says you have to live with the person for a day, a week, or a year, nothing like that. And for those in a spousal relationship, it doesn't. The joint living requirement does not require you to have done that just in a marital relationship. So if you were living with a person before you got married, and you can show that qualifies. So that's really great. That's a new law that actually came up a year or two ago. So that makes it easier for people who are in abusive relationships to meet their burden of proof. So so moving right along. So we've talked about the people that qualify. We've talked about showing that your abuser is a U.S. citizen or green card holder. And we've talked about the joint residency requirement. So let's talk about how to prove that you live together. Well, you can prove that you live together by showing common utility bills. You can show that you live together by showing that you have maybe you share the same address. With your taxes. You can show that you live together with your children's school records or stepchildren's school records. You can show you live together by your driver's license. You can show you live together by mail coming in to the house for you and your spouse. You can show you live together by getting the affidavits of your neighbors or the rental agency. But I want you to know this, that US or your landlord, USCIS will call these people if they feel that, if they question that living arrangement, if they feel that you don't live there, they will call anybody who writes an affidavit, okay? Now, the other thing you need to show is that it is a bona fide marriage. Now, at the heart of every immigration petition, the marital immigration petition, is the finding of a bona fide marriage. Because the easiest way to get a green card is to get married to somebody. So USCIS is really serious about weeding out fake marriages, weeding out sham marriages. So you have to know that you have to show that you're in a bona fide relationship. So let me start from the beginning, right? What is a bona fide relationship? That is a relationship that at the inception, when you guys got married, you had a good faith. It was both of you intended to live together, build a home together, a good faith marriage, right? Now, if the marriage didn't work out later on, that's irrelevant. The law says that what should be looked at by USCIS is what your intentions were at the time you got married. And to get those intentions, they look at several factors, right? Now, before I get into those factors, let's talk about the fact that for you to be in a bona fide marriage, you have to show that when you got married, both of you were able to be married. You had not been married before and not properly divorced. So if you've been married before, you have to show proof that a divorce was properly done, right? Now, if you marry a U.S. citizen or green card holder, and you find out that later on that they were not properly divorced, that it was a bigamous marriage, which means that they were married to you and married to somebody else, and you can show that there was a valid ceremony when you got married to them, and you can also show you had no idea that they were married before and they were not properly divorced, there's an exception called the bigamy exception, which allows you to still file for VAWA even though your marriage is, void because the prior relationship had not been properly terminated. So that is only applicable if the U.S. citizen or green card holder is a person in a bigamous who didn't get divorced properly, or didn't even get a divorce at all. Because I've seen people who just married somebody else without even getting a divorce. Now, if it's a beneficiary who was not properly divorced, whose prior marriage was not properly terminated, you don't get the evidence. You don't get the benefit of the bigamy exception. And unfortunately for you, it doesn't matter how egregious the abuse was, you cannot file VAWA because your marriage is void, because the previous marriage was not properly terminated, right? Now, you might qualify for something like a U visa if you qualify, but you would not qualify for VAWA. That's why it's so important, guys, make sure your divorce decrees are properly done. If you're here in the United States, you do not have to go to your country or have somebody file a divorce in your country. You can file a divorce right here from the United States and divorce people who are in your home country, okay? And that's actually even better because nobody's going to question a divorce decree here in the United States, right? But a lot of divorce decrees from several countries, Nigeria especially, are questioned. I mean, USCIS has actually taken the position now that, it seems, at least to me, that they deny all these cases and say, it doesn't look like a real divorce. And then you have to prove that it's a real divorce. They're not even trying to make the effort to figure out whether it was properly terminated or not. They just say, it looks like it's not a real divorce because of this error. I mean, there are lots of court offices that make mistakes, but USCIS will take a little mistake and say, nope, it's not a real divorce. And then you have to authenticate the divorce. So if you're here in the United States, I would say, go ahead and file your divorce decree before you get married to somebody else, just to make sure that it's a proper divorce. If you've already been divorced, you want to have somebody go to the courthouse and show that those records are there, right? In case you're asked to authenticate your divorce decree. And in certain countries, if you're married in a traditional marriage, a cultural marriage, you may not be required to have an actual divorce decree. Sometimes all they ask for is that you show that you return the dowry or whatever it is that the country requires. Now, to figure out what is needed in each country, you can go to travel.state. USCIS outlines what they're looking for in terms of birth certificates, death certificates, marriage certificates, and divorce decrees. They have it all listed there. So hi, Wasif, Joe. I'm gonna get to your questions. I just want to finish up my presentation and then I'll answer the questions. So, how do you show a bona fide marriage? Well, if you have children, that works perfect, right? If you have joint accounts, USCIS loves financial commingling. They love to see that both of you are using joint accounts, joint bank accounts, and that those joint bank accounts are actually being used by both of you. They like to see that you file your taxes together, They want to see that you have joint financial interest, credit cards, car leases, insurance, life, health, car insurance. They like to see photographs of your life, showing you with family, friends, a slice of your life, right? And I'm going to give you a little tip here. Those selfies, just you and your spouse all the time, they're not really helpful. USCIS wants to see that you're presenting yourself to the world, to your family, to your friends, as a couple. So in that case, social media comes in handy if you have pictures on social media and people are commenting on the pictures, that kind of stuff. Those are ways to prove that it is a legitimate relationship. And sometimes you can have affidavits from family, friends of both parties, showing that if you're still on good terms with people who know you guys as a couple who are willing to write an affidavit, that would be great. So you have to show that it's a bona fide relationship, right? Okay. Um, let's see now. Let's talk about abuse. That's the core of VAWA, Violence Against Women's Act, showing abuse. I tell you, I've seen so much abusive conduct that some things I see, I'm not even kidding you, it troubles my soul for days. I kid you not. I kid you not. And sometimes it's not even physical abuse. It could just be just the torture, you know, you know, um, knowing that somebody is reliant and dependent on you. Like sometimes you have people who, encourage their spouse, their girlfriend, boyfriend, spouses, whatever, to come, stay in the United States. Don't worry, I love you. I want to stay with you. I want us to get married. Don't go back. Stay here. Let's build a life together. And then when you get your papers, we'll go back. And then the person leaves maybe a great job, whatever it is, back home, thinking that everything's going to work out perfectly. They'll file papers and they'll travel together, and it doesn't work out because once they get married to that person, things begin to fall apart. And at this point, they cannot leave, because if they leave, they probably won't be able to come back for another 10 years, right? So they're in a position where they have no job, they cannot work legally. They're reliant on this person for to be able to take care of themselves. They rely on them, or to be able to eat, for where to live. They're afraid to call the cops because they feel that if they call the cops, they'll be deported. And their abusive spouse takes advantage of this. They're like, nobody's going to believe you because I'm the U.S. citizen. I'm a green card holder. You're out of status. Nobody's going to believe you. And you see people in such horrible situations. They might have children and their children are being abused, but they're afraid. you know so if this is you, listen, there's a way out. I told one of my clients, I'm like, you're gonna get killed by this woman because the abuse was so horrific. You are not safe. And I find that a lot of men are ashamed and embarrassed to admit that they've been abused. So it takes, it's like pulling teeth to get them to talk about what they've been through, right? Or what they're going through, especially physical abuse. They don't want to talk about it, they don't want to tell people. And so let's talk about, you have somebody who's destroying your stuff, destroying evidence, burning your clothes. I've had clients that has happened to. You know, um, they won't let you talk to your family members. They won't let you talk to your friends. Um, they lock you out of the house. You have nowhere to go. They drive drunk so that they endanger your life. They force you into things you don't want to do. Like there was a client that her spouse was forcing her into threesomes. If you don't do this, I'm going to call the USCIS on you. You need me, right? I don't need you. You need me. And if you don't do this, well, guess what? I'm not going to file your papers. I'm not going to show up for the interview. I'm not going to do this. So if you're going through, if you're in a relationship where you're being treated badly, right? And USCIS likes to distinguish marital tensions from, which is, I guess, what they assume may occur in every marriage or any marriage, from abuse. If you're not sure, talk to an attorney that does a lot of VAWA, because abuse is, sometimes it could be contextual, right? You have somebody who knows you went through a real, maybe you were raped as a child, and they tell you stuff like, well, it's probably because you're a whore, that's why you were raped, it's all your fault, and you can never be anything. Look, such just things to torture you, to make you feel like you're not worth anything, because that's how abuse starts. Typically before physical abuse starts, it starts with emotionally torturing the person, making them feel like they're nothing and nobody and they don't deserve anything better. So I had a client that one of her spouse took their child and disappeared, you know, and then the people who are being forced to work multiple jobs, and I think this happens with a lot of men, because financial abuse is typically men, force them to work a lot of jobs so that they can support the lifestyle of somebody who refuses to work anymore, because they feel like, well, I'm doing so much for you, I deserve better. Or somebody who just talks badly about you to other people because they feel that your status as an undocumented person makes them unable to live the life that they should. So there's just many ways that abuse can show itself, right? And so if you're in a relationship where your spouse is holding, filing for you over your head, making you, holding you hostage to certain things, you have to do this, otherwise I'm not showing up for the interview, I'm not doing this, you might be able to file VAWA, but remember, it has to be a bona fide relationship. If you get married to somebody and you pay them to marry you and they, treating you badly, that's not, you're not getting VAWA from there. Just want to be clear about that, because sometimes people have relationships that are questionable and they get badly treated in that relationship and they think that that will qualify them for VAWA. It has to be a real good faith marriage. So now, what are the ways you can show abuse? If you have a restraining order against the person, that's a good, that helps. Police reports, affidavits from friends, family, neighbors, people who have heard, who are direct witnesses or indirect witnesses because you told them about it. If you've ever been in a shelter where, you had to run because you were in fear of your life. If you have counseling records, you've seen a therapist, you have photographs showing the bruises, the injury, the scratches, the destruction of your property, the destruction of the house, that could work. If the person who abused you had a criminal record, was as a result of the abuse, that would be helpful. Domestic shelter records, and I said medical records is helpful, even if you don't say the real reason why you're there. Because I've noticed a lot of people who have been physically abused, when they go to the hospital, they don't want to say the reason they were abused, but that's fine. That's USCIS knows that abuse, knows the nature of abuse. They do, Now, if it's a child, if there's school records, where it's noted that the child had said something to a teacher, or letters or texts from the person who abused you with apologies or something to that effect. Those are ways to prove the abuse. And of course, you have to show that you're a person of good moral character, which means that you haven't been arrested for certain crimes. You may have been arrested for certain things which may qualify for a waiver, but typically there's certain crimes that you will not qualify for a waiver. So a component of VAWA is that you're a person of good moral character. You can show that by doing a FBI report to show you've never been arrested, or get a police clearance from anywhere you've lived for, I think it's up to 6 months, at least in the past 3 years of your filing the VAWA petition. And if you have, you've done community service and there's somebody who could write a letter about that, that would work. There are just many things out there. I tell you, you never really know what you can do until you're looking for the proof that you need. And then, and that's the part I love about, the work we do, where it's dynamic. We're always thinking, how can we help this client different from how we help this one, because their situations are not the same. So, so those are some of the things you need to show to prove a winning VAWA case. All right. Now, what are the advantages of VAWA? Hey, number one, it doesn't matter how you came into the country. If you came in through the border, typically if you came into the border without being inspected and admitted, even if your spouse files for you, you have to, file a waiver and leave the country and come back. If you're filing VAWA, you don't have to do so, right? That's one big plus for VAWA. Also, another advantage of VAWA is that your U.S. citizen or green card holder abuser is not going to get in trouble because VAWA is not really looking to punish people who are abusive. They're looking to protect the victim. So they're not going to refer the case to the police so that your spouse can get arrested. No, they're looking to help you get your green card so that you can get past the abuse. You can begin to live your life, free of the abuse. So if you're afraid that U.S. citizen or green card abuser is going to get into trouble, that's not happening. VAWA is confidential. All right. The other thing is your abuser will never know because, again, VAWA is confidential. They're not going to tell them. Even if you live in the same house or same apartment, most law firms, like my law firm, we use our address as a safe mailing address, which means you don't get any mail. We get all your mail and we upload it to your portal when the mail comes so that you can sign in with a password and check your mail. So that way, even if you live with the abuser, you can still get your green card without making a decision whether you need to live right then and then. That's another thing. VAWA doesn't require you to leave your abuser. It doesn't require you to stay with your abuser either. There's just no requirement of any of that. The only thing is this: if you divorce your abuser or the abuser dies, you have 2 years within which to file your VAWA petition. Otherwise, you are out of luck. Another advantage of VAWA is if you're in removal proceedings, you can get out of removal proceedings. That's deportation through VAWA. Because a lot of people go into deportation proceedings because maybe the spouse didn't show up for the interview or the spouse showed up and lied and the case was denied, and then the intended immigrant was now put in deportation proceedings. So if you could file something called VAWA cancellation or removal, or you can file an affirmative VAWA case, either of which could get you out of removal proceedings, out of deportation, if you pursue your case successfully. We've done that for several clients. Now, the other thing to know is that advantages of VAWA is that after 3 years of getting your green card, which is a 10-year green card, you qualify to naturalize, as opposed to other times when you would have to wait 5 years. Like if your mother filed for you, you have to wait for 5 years. With VAWA, if you qualify under VAWA, you get a green card. It's a 10-year green card, and 3 years after that, you can file to naturalize. So let me answer some questions, and I have to go because I have 5 more minutes. So let me start with Ayodele says, when VAWA is approved, what comes next? So Ayodele, that's a really great question. So typically, VAWA is filed. VAWA is the I-360. Now, VAWA is just a deferred action, which means that you were approved and you won't be deported. But to get a green card, you actually have to have an adjustment of status filed. So if you filed it in a one-step filing, the VAWA unit will notify the adjustment of status field office that your case has been approved, and at some point they will call you for an interview. Now, recently we have not had any interviews. We're getting green cards approved for our clients without the need for an interview. So if they waive your interview, what you'll get typically is the request for evidence asking you to go do your medicals. Okay. All right. So let's see what Wasif says. In case USCIS sends an RFE to provide more evidence of psychological/emotional abuse after 2 years of filing I-360 VAWA, and by that time, a petitioner may already be recovered and healed from the abuse, would it still be possible to see a psychologist, therapist to get an evaluation report after 2 years of abuse? So Wasif, this question is really context loaded. If you get an RFE after 2 years of filing VAWA and they want more proof, Well, it depends on what they're asking for. Um, Sometimes a psychological evaluation may help, but not all the time, because sometimes USCIS may say they may say that you know there's no proof, but what they're really looking for maybe something you already have but you didn't submit. So I've seen USCIS say a psychological report was done just because of the RFE, and we have a way to respond to that. So your question is not a question that I can answer on a live. It's actually something I would need to answer when I review the RFE, figure out what they're looking for, and figure out what you have. It requires thinking outside the box, because yes, you're right. Sometimes 2 years later, you may not have all of the evidence, but you may be surprised what you have. And sometimes you may not have provided a really strong uh, uh, filing previously, and then you just need to make it stronger. We've done that. Actually, we've done that so many times. We had, I think I talked about a woman who worked for me before, that somebody had filed for her before she started working for me, and then she found out that I did VAWA and wanted me to assist her when an RFE came. I didn't really want to. I want Because she worked for me, I kind of was a little hesitant to take the case, but she really wanted me to help her, and I felt compelled to. So I reviewed the things that were provided before. I reviewed the RFE, what they were asking for, and we rewrote her declaration again. We didn't have new evidence. We just explained certain things, right? And we're able to pull out certain things that she had that she didn't think was really powerful, but we were able to use it and show that it was credible. And then we use case law to buttress the burden of proof that it's any credible evidence, and this is credible, and this is why it's credible. And she got her VAWA approved. That was the latest one we did, but we do this all the time for people who have their VAWA filed, who have an RFE. We have to rework the case all over again. I hope that helps, Wasif. So let's look at what Joe says. Joe says, can inability to attend stock interview attend VAWA case? How long does it take for VAWA to be complete? Just asking for a friend. I think you're saying, can inability to attend stock interview attend? I don't know what you're saying though. Can inability to attend stock interview affect your VAWA case? You're saying, okay, I think what you're trying to say is, if you didn't attend the interview, and I think maybe you mean Stokes in the interview. If you didn't attend your Stokes interview, does that affect your ability to file a VAWA case? Not necessarily. It all depends. You have to explain give your story. It's really based on your story. What happened? Why didn't you attend the Stokes interview? What was going on? It just depends on your case. What happened? You just really have to explain the abuse you suffered. That you didn't attend your Stokes interview doesn't mean you didn't suffer abuse. It just shows you didn't attend the Stokes interview. There's no requirement to attend Stokes to be able to file VAWA, okay? So Wasif says, I was married at the time of filing the I-360, and divorce was in the process with the court in the US. Now, the marriage is legally dissolved and I received a divorce decree. Should I submit a copy of decree as a supplemental information to USCIS, or just wait in case they ask for it? Wasif, you can submit it. You can submit it, but when you submit it, make sure you put a copy of your I-360 receipt, and make sure that you have your E number so that they can, make sure you're sending to the right place, because now they're sending it to Nebraska. So yes, you can submit it now or you can wait, but I would submit it now. I typically just go ahead and update. I'm always updating my VAWA submissions, because sometimes we submit and then something really terrible happens to our client, and then we update the submission to let them know, while you were trying to decide on this case, this terrible thing happened. So we do that all the time. So go ahead and resubmit and update it. So Ahmed Garba says, oh my God, I have to go, guys. I sent VAWA case adjust status in November. I sent VAWA case adjust status in November 2022. Then received my prima facie a month ago, then send expedite request for all case, but get approved for work permit only. Can I resend the expedite again? Well, you got a work permit, so what are you sending the expedite for? I'm not sure. You can't really request for them to expedite all of your case, because VAWA is working through it. So they might expedite your work permit, maybe expedite your travel permit. All right. Hi, Portia. How are you guys? Sorry, I gotta go. Let's see if there's anybody. If I haven't answered any question, please just go ahead and just send a question. You can DM me. Send me on a DM because I gotta go. And I gotta go. Sorry, I have a 2:30 appointment. It's 2:32. But it was a pleasure as always being here. Okay, guys, take care. Bye.